Okay, hello everyone. So welcome to the discussion on the role of the court presidents. The discussion is organized by the Network of International Network of Court Reformers. This is a newly created network which is composed of experts from various countries. And approximately 30 people or organizations from 13 countries of Eastern Europe. We are joining, we are getting together from time to time to discuss the problems of judicial administration, of justice administration, organization of judiciary, appointment of judges, and so on. The network is focused on the judiciary. The focus of the network is on judiciary. We don't touch the prosecutor's office or any law enforcement. However, we have experts from non-governmental organizations. We also have members from high councils of justice. We have legal scholars. I think this is a quite impressive network with multiple, with a long and diverse experience. Today, we are going to have a discussion on the role of the court presidents. And we will have a presentation from Mr. David Kosar. He will introduce himself. I'm not going to make an introduction because he has long titles and I don't want to miss anything. And we will have a presentation about the European experience of European models of court presidents. And we will have presentation on the Georgian experience of court presidents. So we will be able to compare various European countries and Georgia. The presentations will take approximately 40 minutes, maybe 45 minutes together. We will try to be very concise, but after the presentations, we should have discussion. And I'm looking forward to have all participants involved in the discussions. Today, at this meeting, we have, oh, sorry, Simona is joining us. Today, we have at this meeting participants from Georgia, from Slovakia, right? And from, so what countries do we have us? Sorry. Simona, he will do the presentation. He will do the introduction himself. We have participants from non-governmental organizations. We also have public defender, Joe from Public Defender's Office. And now, after just hearing about the network, and after hearing about the topic of the presentation, we can start directly. I'm going to ask David Kosar to introduce himself and to start presenting his topic. Thank you, David.
Okay, thank you very much. Thank you very much for having me here. It's my utmost pleasure. I will upload the presentation. Try to do it in a sec before, and now I can't see it, so that's always like that. So wait a second. Even though we tried in advance, I will make it happen. Okay, so now, wonderful. So just double checking with you whether you can see it.
Yes, we can see it.
Wonderful. Thank you so much. So thank you very much again for having me here. I intentionally, first of all, mentioned two names because we wrote together with Adam Blissa a piece in German Law Journal in 2018. I'm building a lot on the piece we put together. So I want to give him a credit. So I mentioned him in the presentation as well. My name is David Kosach. I work as a head of Department of Constitutional Law and Political Science at the Masaryk University, Brno, the Czech Republic. Much of the research that we have done on court presidents has been done under our previous ERC grant from the European Research Council that we got in order to study judicial self-governance. Right now we have another ERC grant that deals more with informal judicial institutions. So that's the background. My presentation will focus on court presidents, as was said, with the underlying title, the missing piece in the puzzle of judicial governance, because I guess we all know that in the post-communist settings, court presidents are very important, and chief justices in particular, but this is not a standard common knowledge, and there is a limited scholarship on other jurisdictions. So here, just a very brief introduction into the topic to those who are not familiar. We have seen an unprecedented rise of the power of courts within the last couple of decades, but slightly, later on and less visible, there was also a rise of role of judges in judicial governance. This is a trend that has often been labeled as judicial self-governance. We can see it in Europe, but we can see it also in Latin America and elsewhere. So it's a worldwide trend, of course. Right now, if you look, for instance, within Poland on Hungary, or within Europe, I'm sorry, on Poland or Hungary, we can see that this is probably not a one-way path, and we can see a sort of, return to the ministerial party ministerial model in Poland, disempowering judicial councils and so forth. So it's more like careening, that we are going up and back. So a lot of scholarship has focused within judicial governance and judicial self-governance so far on judicial councils, mainly in Central and Eastern Europe. But it's also important to focus on other jurisdictions, that is on West Europe, international supranational courts, and also going broader, that is to other regions, and especially judicial governance, for instance, in Asia is a very under-researched topic. In Africa as well, we know very little. There is more in Latin America. There is, of course, more in Canada and the US, but and there's growing scholarship in Australia about Tim Bunjevac, but we are still missing a lot of regions. It's also important, secondly, to look beyond judicial councils and look at other bodies, such as judicial appointments commissions, promotion commissions, special disciplinary panels, but also court presidents, potentially judicial associations, and so forth. And now we also want to focus on informal judicial institutions, because we all know that it is crucial to go beyond the formal bodies and to look what kind of informal institutions, informal conventions are governing the judiciary. I will skip the definition of judicial self-governance. Just want to make clear that it's not only about judicial councils, and court presidents are crucial players within judicial governance, and chief justices in particular. Why they are so important? They are important actors because they have wide powers, and in many countries, becoming a court president is viewed as a form of promotion, and a very important type of promotion. We also need to focus on court presidents because they have dual role. They communicate within the other judges, within the judges at their own court. It is within rank and file judges of their own court. If it's a chief justice, quite often he or she communicates with the rest of the judiciary as such, especially in small countries like Georgia. We'll get to that later. But then, on the other hand, court presidents also communicate with external actors I mentioned the politicians here, but of course they might be all sorts of other actors as well. In global perspective, it can be the church. In some countries like Myanmar and China, it will be the military or the security files, all sorts of other bodies. In some countries where judicial corruption is widespread, court presidents might be communicating to oligarchs and business persons as well. But let's have a look at powers of court presidents. Of course, they are both formal and informal, but according to us, they can be divided into, let's say, 7 categories. The first and most important power, of course, not in every jurisdiction court presidents are having powers in all of those 7 types of powers, but let's have a look at them holistically. So court presidents can have significant powers over judicial careers of other judges. They can have a significant say in appointment of new judges, in promotion of judges, but also in disciplining of judges, because they might initiate disciplinary motions. Secondly, they might have very strong administrative powers, such as control of administrative and material resources within their own courts, assigning law clerks and so forth. They have a strong jurisprudential power. This has been researched a lot in the United States, because court presidents and especially Chief Justice of the Supreme Court of the United States, might assign the opinions to individual judges that might determine the rules of the debate, the deliberation, and in typical civil law courts, where courts are relatively large and they don't sit en banc or in plenary sessions, it's also crucial that the court presidents might divide the court into panels and then assign the cases in between the panels or in between the individual judges. Of course, they can't create the so-called work schedules with sort of general rules, or they can do it on an ad hoc basis. But in many jurisdictions, they have a significant discretion. Yes, so yeah, I deleted the pop-up window. Okay, perfect. Then the fourth power is the financial power, because court presidents, they often wield significant competencies in determining on what court budgets would be spent. In some countries, they may even grant judges salary bonuses, or provide them with various non-monetary benefits, faster laptop, better internet, more law clerks, or all sorts of other perks. Even a parking lot in front of the court building in the capital might matter. Then, and here the Western scholarship is far more developed. Court presidents, especially at higher courts, have also an important ambassadorial power, because they are representing the court at home as well as abroad. They also wield significant media power, because they communicate with various audiences, shaping the public image of the court. In case of court, Chief Justice is also the image of the judiciary. And of course, they might have all sorts of other ancillary roles, that is various extrajudicial duties. As I said, not all court presidents are wielding all of those 7 competencies, but even if they wield some of those, we already can see that they have significant influence over the functioning of the judiciary. Therefore, we need to know who court presidents are, what they do, and how they are selected, and of course, under what circumstances they can be dismissed. So with Ambrisa, we developed a tentative court president's power index, where we try to show how strong court presidents are under each of this area of or the area or group of competencies, and we use the scale from minimal via intermediate to extensive, and then we categorize the European judiciaries plus the Court of Justice, European Court of Human Rights, and we edit Russia. I intentionally not having Georgia here, it would be great to hear from you later on. How would you assess court presidents in your country as well? What we can see, there is a significant difference and significant variance within Europe regarding the powers of court presidents, and even between the two supranational courts, you can see that there are significant differences as well. Then we added values to all of those categories on the scale, and you can see that certain countries like Russia or Czechia or Slovenia, but also surprising perhaps Court of Justice of the European Union, shows that court presidents are having significant powers. There are other jurisdictions where this is not so. In Germany and Netherlands, there has been, I guess, significant development over decades, where the powers of court presidents were gradually curtailed. But it's interesting to see that even in Southern and Eastern Europe, there are certain jurisdictions, such as Romania, where court presidents are not wielding that much power. And I discussed this issue also with the people at the Balkans, Denis Prešova and others who are working on this region. And it seems that there are interestingly also other jurisdictions in the Balkans where even the Chief Justice is relatively weak. I would like to hear more from you on Georgia, for instance. Chief Justice, as far as I heard from Nino Tsereteli, is not that important figure, or has not been that important figure with so much powers until now in Georgia. Surprising. I would like to hear more about that and about the lower court presidents. So this is only a snapshot of countries we studied. Of course, it needs to be updated and needs to be also applied to other jurisdictions. Based on this, we created, let's say, categorization of court presidents according to the types of powers they are having and exercising. So we created basically 5 ideal types. The first is court president as a boss, a typical Russian court president that has a very strong powers in judicial careers, wields financial power, is also strong ambassadorial and jurisprudential power, and also not insignificant media power. Then we can see court president as a judicial leader. Court of Justice, Kun Lenárd is a typical example, but also in Czech Republic, it is in Slovenia. This is the ideal type we are seeing, where court presidents are having less financial power, but again, important career decisions, strong administrative and or jurisprudential power, and then media and ambassadorial power, but not as strong as in Russia. In other countries, we see court president as a manager, where court presidents have sort of weak ambassadorial media and financial power, but significant power of judicial careers and control over case assignment. Then, if you look at the Strasbourg court, then we see court president as a sort of judicial diplomat. Don't want to undermine the significance of the role of the Strasbourg court president, but it seems that his major role is primarily ambassadorial and exercising media power. He has some jurisprudential power, of course, because he sits or she sits on the grand chamber, but basically there is very little power of judicial careers, or that is about the composition of the court and where how judges are promoted to section presidents and so forth. There is also limited administrative and financial power. The registry of the court plays a significant role. And then finally, we have court president as the primus inter pares, where court president has a limited influence over the careers and lives of individual judges. And if he or she has that influence or that power, it is often under judicial review or it is administrative review, and there is a limited discretion. And the court president relies primarily on his or her leadership skills. So these are 5 ideal types. But if we look beyond that, what we found is that the existence of powers, be it formal or informal, not necessarily translates into influence on judicial government, because there are a lot of contingent circumstances that matter. First of them is the length of the term of court president. Of course, the longer the term, the stronger the court president. If there is a shorter term, if there is no chance to renew the term, like for instance in the Czech Republic, that of course weakens the court president, because he or she cannot build around himself or herself the status of celebrity, make important changes, and has limited leverage, because sooner or later this court president will become a regular judge. So of course he or she would not be willing to make let's say controversial decisions, or even some progressive decisions that might meet with some resistance. The other factor is the information asymmetry. It very much depends how much information court presidents have vis-a-vis the other organs. For instance, in the Czech Republic, court presidents are super important, because there is a huge turnover at the Ministry of Justice. There is also a quick turnover of ministers, so there is no institutional path dependence at the Ministry of Justice. Judges cannot be temporarily assigned to the Ministry of Justice, so there is I would say, even a limited knowledge of how the judiciary works within the Ministry of Justice. And of course, court presidents can exploit that information gap. In other countries, judicial councils can have significant information and can have even a better information than court president, because they can see what's going on within the judiciary over the whole country. Let's say in Israel, they have a different model of judicial governance, where a significant role is played by the so-called director of courts, and this person has a huge body of people working for him or her, and collects a lot of information, and it's becoming a power center that is most probably far more influential than court presidents in Israel, of course, leaving aside the Chief Justice of the Supreme Court of Israel. Then the institutional design of the judiciary also matters, whether there is a flat structure or a pyramidal structure. That also affects the way court presidents will influence. If you have a straight pyramid with one Supreme Court at the top, then of course the Chief Justice has a bigger role, and even the appellate court presidents have a significant role, because they have basically the entire judiciary underneath. But if you have a more complicated structure with separate branch of administrative court, with a separate specialized courts and so forth, that of course makes the difference. Then the existence of competing judicial governments or judicial self-governance bodies depends, whether they are judicial councils, selection panels, judicial appointments commissions, management boards, court service, as I said, director of courts. This of course creates a potential alternative information and power center, and might limit the powers of the court presidents. Then fifth, proximity of court presidents to political leaders can also play a role, because if court presidents, for instance, recruit from former ministers of justice or something like that, or if that's what I call traveling among branches, if judges are allowed to spend some time at the Ministry of Justice or at other governmental bodies, then of course that brings them closer to the political leaders, and they can bring that social capital back to the judiciary and have sort of political backing. By super judges, I meant judges who were judges, then they became the ministers of justice, and then they returned to the judiciary. So these people have held top positions at two branches of power, and of course that gives them a lot of informal powers and informal contacts. Of course, in certain countries you have ruling patronage networks. In some countries, court presidents can be connected to politicians via judicial associations or via meetings with general prosecutor or prosecutors in general, or in the local milieu. It very much depends how it works. Then sixth, role of legal profession also plays a role, because in certain countries the legal profession plays a sort of gatekeeping role. That is especially in common law countries, where judges are recruited from active solicitors and barristers or advocates if there is no two-pronged legal profession. But the legal profession can also constrain the role of court presidents, because they may determine what is proper, what is improper as well. They can also protect court presidents by let's say defending their positions against media attacks and so forth. And of course there is a very broad category of legal culture that can make the difference, and especially existing conventions, and of course political culture and political environment. I would add that of course informal institutions and informal networks would be probably even a separate category. So to finish my talk, I put together this slide with broader repercussions. Since I'm really focusing here primarily on Europe, which I know best, even though I use some examples from Israel, Latin America, or from the United States. It seems, of course, it doesn't work 100%, for each jurisdictions, but it seems that majority of scholarship portrays court presidents as a sort of masters of Central and Eastern European judiciaries, while in West Europe they are mostly representative figures, sort of primus inter pares. Of course, there is a continuum, and I showed you more ideal types. But it seems, and that's where we need to focus more, that in certain Central and East European judiciaries, such as Romania, court presidents are relatively weak. So why is it so? How is it so? Who is replacing them in their role? There are also West European jurisdictions, such as France and both supranational courts, where court presidents are relatively strong, but of course, it's not easy to compare domestic and supranational courts. In that case, it would be probably better to compare domestic constitutional courts with supranational courts, because judiciary is usually much bigger. And Slovakia and Poland, they are also somewhere in between. So the standard account about the Central and Eastern Europe does not really work 100%, and it would be great to hear from you about Georgia and other perhaps neighboring countries. The other issue is selection and dismissal of court presidents. We know from the case law of the Strasbourg Court that there has been quite a lot, and from the Court of Justice more recently as well. It's been dismissal of András Kakha in Hungary, from the position of Chief Justice of the Supreme Court. Małgorzata Gersdorf was supposed to be, let's say, got ridden from the Supreme Court of Poland via change of the maximum compulsory retirement age. But there are other examples in Ukraine, Denisov versus Ukraine, Chief Justices, or recently also in Bulgaria that challenged their dismissal before the Strasbourg Court as well. So there are examples in Slovakia, attempts to dismiss court presidents in Czech Republic as well. So it seems that in East Europe, we have not placed that much emphasis on selection, and dismissals were relatively common and often very contested before domestic constitutional and supranational court. While in the West Europe, there is a strong emphasis on selection. Dismissals are very rare. It sometimes happens, but usually due to some improper behavior, the chief justices and court presidents resign themselves. That was the case, for instance, in Spain, a decade ago or so, when the chief justice of the Supreme Court resigned because of some alleged misuse of public funds. Then, of course, the big difference is between chief justices who sit at the very top and lower court presidents, and of course, perhaps mid-level court presidents. It very much depends how the judiciary works in a given country. It's easier to focus on 1 or 2 or 3 persons at the apex courts. It's much trickier to look at the lower court presidents, but that's the crucial part, and they usually outgo the other. And you can see that the Hungarian reform, when there was introduced a lower compulsory retirement age for judges, it affected primarily Supreme Court judges and court presidents, who were the most senior guys, and that allowed Viktor Orbán to replace them by their own proteges. The same applies to Poland, where Zbigniew Ziobro also managed in a short window to dismiss dozens of court presidents to install the pro-government people. So we need to focus on the lower level as well. That's in the end where the first instance, criminal and civil law trials take place anyway. So it's crucial in judicial governance. Then, of course, we need to focus on judicial politics. That is interaction with other organs, communicating, informing, advising, negotiating. When when court presidents initiate reforms, when they resist the reforms adopted by someone else, how they implement them in good faith or bad faith. It all depends how they react to the possibility of a creation of a new judicial self-governance body, or whether they view it as a sort of challenge to their authority. That can happen everywhere, not only in Central and Eastern Europe, but look at Ireland, for instance, when it has been a big deal as well. Court presidents were very keen on making sure that the new judicial council will not affect their powers. And of course, there is political contestation. And we need to think about the questions such as, are some court presidents' powers more prone to political attack, or are some ideal types of court presidents more problematic and probably inviting political attacks? Of course, the stronger the court presidents, the more likely it is that political actors will have the incentive to have a certain influence over there. And of course, we need to understand also the logic of the other side, especially the politicians, maybe also the oligarchs and other actors, external actors, why they meddle with court presidents, what they expect of court presidents, where is the red line beyond which they are willing to dismiss all court presidents or attack him, or what they expect from a person to do at a given court, and what kind of motivation they are having. So that's my set of issues. Thank you very much for your attention. I'm looking forward to your questions, comments, and of course, to your experience from your jurisdictions. Thanks a lot.
Thank you. Thank you very much, David. I apologize for having made a mistake in the agenda. According to the agenda, we have a question and answers now. And then we shall have a presentation on the Georgian legislative framework and practices. And then we will have a separate discussion after the second presentation. So now
it's up to you. It's up to you. It's up to you. How do you design it?
Yeah, I think it's better if we ask you the questions that we have at this point, and then later on also some participants can also retain their questions for later. As far as David stays with us, right? You will be with us by the end of the second presentation, I hope so. Okay, First, let me just start. I will just abuse this power of facilitator, and let me start by questions. And then please raise your hands later for your questions, and we'll be happy to have questions and opinions from the participants. My first question is about the selection procedure and selecting body for the court presidents. If the court presidents are selected by the judiciary or by the executive body or by elected by the judges themselves, I want to know particularly if you have any countries in Europe where the court presidents are elected by the judges. The judges are elected the court presidents as part of the self-government, because this is something that has been circulating here in Georgia, the idea for about 4 or 5 years. It did not come up to the law, but it was circulating for a long time, and we'd like to hear if something like that exists. This is my first question. My second question is about power of the court presidents when it comes to the case flow management. The case flow management. I'm talking about the case delay in the court. Let's pick up a particular example. Let's suppose that a judge is taking a long time to finish the cases, violating procedural deadlines, and having the judges having a pending cases for 2 or 3 years, the cases which are pending for a long time. My question is it possible for the court president to go to the judge and ask the reasons of the case delay, ask some kind of information about this case delay? And also, what is the role of the court presidents? What is the role of the court presidents in developing the case law, the uniformity of the case law? Do they have any role in developing, like in fostering the uniformity of the case law? That will be my third question, actually. Thank you. So how do you prefer, David? Would you like to answer my questions?
Let's collect more, and I guess, give the floor to others. If they have any questions, I can collect a couple of more, and then I will reply to them, so that it's not just a conversation between the two of us.
Okay, excellent. Please, I'm asking to other participants, if you have questions to David, questions, opinions, please, you're welcome. So far, no questions. So you can, David, or Peter, do you have questions?
Yeah, if I may join with my question for David. David, you are very aware about the situation in Slovakia in the past years, especially about Trema scandal, right? Could you tell me what is your insight or what is your opinion about the role of the court presidents in the scandal? There's most of the judges who were accused of the bribery and corruption came from particular Bratislava courts, and then the affair that was the scandal that was not directly connected, but also the corruption scandal in Žilina. There were also the court presidents where somehow they took part in the activities in the corruption. So what is your opinion about their role in that affairs?
Okay, thank you. Anything more?
David, let me also ask you about one more question about the case assignment. Is it always necessary that the case assignment is done by the president, even when there is some kind of automatic case assignment, can the presidents interfere in the case assignment, even in the countries which have the automatic case assignment system?
Yeah. Okay, so I'll start responding to questions. It very much depends. I mean, I will start in the opposite direction. So whether court presidents can interfere in case assignment, even if it is automatic. In some countries, they did so. I mean, it was typical in Slovakia. I mean, Chief Justice Harbin didn't like the automated system. In some countries, there is no right to a lawful judge, in a sense that that would require automatic case assignment. Many West European countries worked on that assumption, and the right to lawful judge, as we know it from Germany and many jurisdictions in Central Europe, did not exist there. And I mean, the United Kingdom has also been a typical example. But I would say this has changed. There is a growing pressure that this is not a good practice. There is a growing case law of the Strasbourg Court that is trying, to read the right to a lawful judge into Article 6 of the European Convention. And early on, it did it so under, the label of independent tribunal. Right now, it seems to me that it's doing it under the label of the tribunal established by law. So I guess there is a growing pressure to move into that direction, that basically there should not be any discretion of court presidents alone to interfere in case assignment or reassignment. So reassignment is also very important, because if the initial assignment is done on automatic basis, and then the court president can basically, under the let's say invoking the criterion of an even distribution of caseload, or let's say even work capacity or something like that, if they can reallocate the cases, that basically leads to the same result like the initial discretionary case assignment. So in my opinion, the ideal solution that is there is what, for instance, and Peter can correct me if I'm wrong, that developed in Slovakia at the backdrop of huge abuse of case assignment and reassignment by court presidents, where basically it is clear that this is done on an automatic basis. You need to have, and that's the problem for small countries and small courts, you need to have at least two panels dealing with each set of issues, so that you have at least a choice between more panels. Because if there is one panel specialized in a certain area, that basically case assignment doesn't make much difference. And that's also in theory a case for a connected issue for bigger courts. There has been a change of judicial map in Slovakia very recently. There's been a change in Norway. So there is a trend to reduce the number of courts and make them bigger. And of course, that solves a lot of problems in itself, because once you have a bigger court with more judges, it means that you have more choices. And let's say the random is random, but in big courts, the random case assignment actually becomes more random, because you have more panels you can choose from, and therefore for anyone who potentially might be thinking about corrupting courts or bribing judges, they are in a difficult situation, because the case might end up before several panels. And then of course increases the costs and reduces the likelihood that the case will end up before a judge you want the case to end up. So right now the practice, short answer is, right now the practice varies. In several countries, there is certain discretion of court presidents, both at the initial case assignment as well as with the reassignment. But then the new case law of the Strasbourg Court, I think it's making it far more difficult. And definitely, if the case arises that, for instance, someone is ill for a long time, or a judge, there are all sorts of those situations. Judge is temporarily assigned to a higher court or something like that. Judge goes on paternity or maternity leave. Then, of course, the cases this judge is having must be, transferred to someone else. And then we go into very, very details. And of course, the devil lies, the proverbial devil lies in these details, whether you have a substitute defined already in advance, or whether you have a special system, how those cases are reallocated, whether it's done by a court president, whether it's done automatically, whether it needs approval of a judicial board or something like that. Then it of course gets trickier. Then corruption, judicial corruption in Slovakia. Well, since this is a recorded session and we are discussing potential criminal behavior, I should be probably very careful.
We can cut out this part if you want to say something.
What I'm saying. But I will use the Czech example, because there is a case that is also being investigated of the alleged corruption of a high court judge in the Czech Republic, and it seems that and that I'm almost sure that the court president is not involved, but sometimes it just may happen, and it must be used as an opportunity to revise the system to make sure that the case flow is far more transparent, and then there are no holes, and that the court president knows what his or her judges are doing on the court. Of course, if court presidents are involved in judicial corruption, that's highly problematic, and I guess in the long term, only the peer pressure and legal culture can prevent that from happening, because court presidents wield significant power. They also have more information than rank and file judges, and it's really tricky. If they are involved in such behavior, that's highly problematic. So then again, we can think of some kind of innovative solutions, having an ombudsperson, hot links where judges may anonymously put information on potentially problematic behavior on a certain court. And then you have to have a sort of investigative unit, either of the Judicial Council or another body that can probe this potentially problematic behavior. So it's tricky, and it's not easy to eradicate judicial corruption in general. When it comes to court presidents and they are involved, that's even more complicated. I don't want to discuss the individual cases in Slovakia. We'll see the subsequent criminal trials. Then, regarding role of court presidents, whether they can foster uniformity of case law, I guess this is a very interesting question, and it would be nice to have a comparative knowledge about that. I'm not so sure whether I'm having it across across Europe. But it seems to me that we in Central and Eastern Europe are sort of used to the practice called interpretative guidelines or something like that, that, you know, apex courts try to unify the case law, and they do so via these interpretative guidelines, or they do it via the Grand Chamber. To me, if there is a divergent case law, a standard way how to address that is via the standard procedure, that is, you know, challenging this issue before the Grand Chamber of a given court. If it's at the apex court, at the lower court, I guess that can be tricky if court presidents try to basically persuade judges to change their opinion. And in most West European countries, that would be an improper behavior and a violation of individual judicial independence. I think that in Germany, I would say, even if a court president, and that goes even further, wants the judge to fasten, you know, the decision in a certain case, or because there are delays or something like that, and wants from an individual judge, you know, to do something, that again might be problematic from the point of individual judicial independence. So it's again gray zone, and it's very tricky. Of course, court presidents, and that goes to the case law management, because these two questions are, I guess, interrelated. Court presidents first should have information what's going on within a given court. I don't know what's the practice in Georgia, but it's not easy to develop a complex intranet where you have all, you know, files of decided cases that are tagged, because you know which area it concerns, what's the prior case law cited by this judgment, whether there is a legal head note or some kind of a new part of a judgment that create a new rule or something like that. So it's a lot of steps, and then if you have this proper, you know, system, it allows the court president to see not only how many cases are disposed by a given panel, by a given judge, but in a given area of law, how many hearings there were, or something like that, but also can see divergences among judges, and can see, for instance, that, you know, if there is a growing docket of a certain, you know, judge rapporteur, sooner or later this must be discussed. Again, it depends on a given jurisdiction whether there is a small talk between a court president and a given judge, or whether it is discussed with the judicial board, or whether it is discussed at the plenary session. But quite often, if you send, let's say, on a monthly basis, the table of the unfinished cases, and each judge can see, I mean, where he or she stands in this so-called ranking, then, you know, it is often in itself enough and sufficient motivation for those who are lagging behind to get better and improve their performance. Of course, if it's not happening, then you need to have several steps how to handle that. But it very much depends who can initiate disciplinary motions, who can have this, you know, who can have this small talk, whether this is decided by, you know, judicial council or judicial board at a given court, or whether it is court president or something or something like that. So it's really tricky, and I think there is not that much, scholarship on this. And finally, where court presidents
David,
are elected by
please,
judges.
before you
Go
move
ahead.
to the next question, can I just jump in? Can I give you just very short, very quick question? Do court presidents monitor the work schedule of judges? What time they come to the court, what time they go? Or they don't, maybe they don't come at all, just work from home and they don't care about coming to the courthouse. Do you know that?
That again, from the jurisdiction I know in the Czech Republic, that varies a lot. They have been court presidents who were, micromanagers and ask judges, to beep when they enter the building. Then when they leave the building for lunch, again, they have to, use the card. And if they spend on the lunch more than half an hour, then they will have problems or something like that. And you had this a particular period of the day when you had to be at the court. For instance, between 8 a.m. and 3 p.m. you have to be there. You can take only half an hour break, and then you cannot work from 10 p.m. until 6 a.m. or something like that. You have to be there every day. It very much depends. So there are court presidents who are really micromanagers. On the other hand, there are court presidents who give their judges more autonomy and leeway, and basically leave it up to them. Maybe they want to squeeze the hearings into 2 days, and then they are writing the judgments at home or elsewhere. It very much depends. Of course, if there is e-justice and you have files electronically, that makes life easier in many cases. And it also very much depends whether you are at the court where many hearings take place, or whether you are an apex court where mostly everything is done in writing and hearings are very rare. So there is a huge divergence. So it very much varies, and I'm not even able to say which system is better. I of course understand that individual judges want to have as much autonomy as possible, but on the other hand, I also understand the court presidents that they want to see their judges sometimes in the court building, and who want to make sure that files are not taken outside of the building, are not being lost, and I guess that might, maybe not now in the current COVID era with home office and so forth, but previously I think if someone from a TV station would wait in front of the court and not just record who is entering and who is leaving the building, I mean, I guess for many people, just symbolically, it would be highly problematic to see that judges are, let's say, working 2 days a week, 5 hours per day, and then they go home and do whatever they want, and they are earning their high salaries for that. So there is also a potential legitimacy problem. So we'll see. But it's really complicated. And whether court presidents are elected by judges in any European country, well, I would have to double check. Surely court president is elected at the European Court of Human Rights. That applies to section presidents as well. I'm not so sure about domestic jurisdictions. I would have to double check, but I guess it also very much depends what role the court president plays. If he or she is having a significant role, then most probably it will not be judges of a given court that choose the president. And I'm not even sure whether this is a particularly good idea in all cases. It also depends what powers these court presidents have. For instance, if they can initiate disciplinary motions, then of course judges will choose someone who will be weak in a sense, and will not want anything extra from them, which is not necessarily what you want in judicial governance, because you want to have a good manager who will monitor what's going on, lead by example, and ensure not only rule of law values such as judicial independence, but also efficiency, quality of judgments, transparency, and so forth. And of course, the person who is elected by judges might not necessarily want to do that, because it will meet with resistance.
Thank you very much, David. Before I move to my presentation, and it's actually Kakha has joined us, she was unfortunately she was busy with the television. And
may I say a few words?
Yeah, sure.
Please.
Hi. I apologize, first of all, for this delay. Thank you, David, for participating and for making this presentation, which I will listen the recording for sure, but I was not present. And I will just seize this opportunity to ask one question, if I may.
Of course, go ahead.
I don't know, maybe you already touched it, and if so, then just give me a quick answer, and then I will go back to the recording. But are you aware of any jurisdiction where court presidents are not represented as with traditional, so-called traditional functions? Because we were considering here to maybe have a court president only with representative functions. I understand that somebody could be, should have this power to initiate disciplinary proceedings. This part aside, court president with only representative functions, or
you mean ambassadorial? I think that
yes.
David calls it ambassadorial function.
Yes. Or maybe jurisdictions where those functions which are usually with court presidents are performed by a group of judges, collegial body in the given court. This is my question. Thank you.
What do you mean by these traditional powers? Which powers you consider?
Case distribution, for example, or specialization, defining specialization of judges, or the group of appointing judges in the considering chamber, for example, to allocate concrete judge to concrete chamber. Basically, these functions are critical, I guess, if we are talking about Georgian experience, for example.
Yeah. So I guess as I said, the court presidents are relatively weak in Germany, Netherlands, and Romania. Out of those jurisdictions, we have studied, but I can't say that they would have only representative powers. I guess in every jurisdiction, court presidents, at least in Europe, play a certain role. I think only in the US, at some courts, it really works differently, where court presidents are elected or they rotate every 2 years or something like that. So it's really more or less about this ambassadorial function and overseeing certain operations, but it's not connected with any extra power or prestige. It's basically taken as a sort of head of department at the law school. So you would have all members of the department rotating every 3 years, because no one really wants to do with that admin all the time, and you would have a rotation, and you can see that everybody knows what's going on within. But it's in Europe, we have not seen anything like that. When it comes to case assignment, I think that a typical example is Germany or Austria, where court presidents are, are having very little role. They sit on the body that decides on this, work schedule and the case allocation and reallocation, but they are in the minority. So there are other members of the court who basically may limit the discretion of court president. I mean, court presidents are sitting there because they need to know what's going on, but they don't have the decisive power. They don't have even the majority. I think I would have to double check that in Nordic countries, much of this is done by the court service. I don't know on how much detail the court service decides on the case assignment on a given court. And in Germany, it's also important that there is a possibility of judicial review. So if a judge does not like the way cases are distributed, he or she can challenge it before the administrative courts. So even if court president is not the single body that decides, even if it's the collegiate body, there is still a possibility of judicial review.
That is important. It seems there are some balancing powers as well.
Yeah. So that you want to have the system functioning, but you try to limit, discretionary power, and you have let's say, safety valve if there is an abuse or something like that, so it can be rectified on a judicial review. There's been a big discussion in the Czech Republic. There is a case like 9 years old when the Supreme Administrative Court said that it's not possible to review the work schedule, the way cases are assigned and allocated, but it's been criticized since then, and there is a new case pending before the Supreme Administrative Court, and we'll see whether they will be willing to overrule this judgment, because this judgment was based on an assumption that in Germany there is a judicial review, in some countries there is not, and in Austria there is administrative review. So then this assignment, problematic case allocation, is decided by the collegiate body of the higher court. So basically, if you don't like the way cases are distributed at the district court, you can go to the regional court body that will decide. So it's not judicial review, but administrative review. And the Czech Supreme Administrative Court said, well, in all countries comparatively, there is no judicial review. We don't have it. We don't need to have it as well. But you can also argue the other way around and say that basically in the neighboring countries, there is at least some kind of a review, even if there is a collegiate body deciding in the first place. So if there is a court president who decides unilaterally, you need review even more than in Germany or Austria. So we'll see whether this logic will be applied in future or not. But yeah, so that that would be my response. And of course, you can devise a system of automatic case assignment and reassignment that does not require basically anything from the court president. But again, as I said earlier, I'm not sure where exactly you join. It also depends how big the court is. I mean, if they are, if it's a small court with 10, 12 judges, and you have 4 3-judge panels, and 2 of them focus on civil law, 2 of them on criminal law, and you have a specialization within. So you can have a fantastic random case assignment, but in the end, it will always, end up the same before the same set of judges. So that's the problem. And the specialization. Yeah, go ahead.
You mentioned weak court president. I just managed to write down Germany. Which countries were there? Also, several countries you mentioned with
Germany, the Netherlands, and Romania.
Okay, thank you.
I think regarding Romania, there is a review of my book, Perils of Judicial Self-Governance in Transitional Societies, written by Bogdan Iancu, and he reviews it from Romanian perspective, and he's devoting several pages saying basically that, you know, my assumptions do not work for Romania because court presidents are weaker over there. Of course, I mean, he doesn't explain, you know, why is it so that will have to be investigated separately. But there are some jurisdictions where this is the case.
Thank you.
Thank you, David.
Careful. May I just one thing? Just be careful when you disempower court presidents. The power does not disappear. You have to transfer it somewhere else, and this another body may, you know, face similar problems or even different set of problems. So in my opinion, I have, you know, slightly changed my views, because I mean, court presidents are super powerful here in the Czech Republic, problematic, but without them the system would not work. And that's the tricky point, because we are non-functioning Ministry of Justice. We don't have a judicial council. We don't have any judicial appointments commissions. So you know, you have to create a pressure on court presidents to behave, you know, appropriately, to be transparent, to improve the procedures. But disempowering them might get tricky, because I'm sorry, you might end up with a new set of problems. I mean, Petr Čuroš can tell you that they moved from the Ministry of Justice model to the Judicial Council model. That was supposed to be, you know, great new solution and bright future, but in the end, you know, it create all sorts of new problems, and it did not solve some of the previous problems either. So it's tricky.
Right. It matters where you transfer this power.
Yes.
David, I know that we have taken a long time, your presentation and discussions, but I have a very quick question before I move to my presentation to you. It's about the case. It's about the case load of the court president, the jurisdictional power of adjudicative power of the court president. Do you have examples where the court presidents have certain quota for adjudicating cases? For example, 50% of regular judges, or 10% for regular judges' caseload or something. You know, the reason I'm asking is that you can have a lazy court president who can completely ignore adjudicative function, and the court president may say, I don't care about adjudicating cases. I am a manager, so I can sit here and just watch the other people work, and I'm not gonna adjudicate myself. And we did have cases like that in Georgia. We did have specific cases like that in Georgia. That's the reason that I'm asking.
That's a very interesting question, and I guess it's been a public secret in the Czech Republic that certain court presidents in the past were not deciding cases either. But the problem was that we could not see it. You could just, that was just a hearsay, because there is no judicial performance evaluation that would be, holistic or meaningful. There are not even publicly available statistical sheets so that you could see how many cases were disposed by judges. Of course, they don't like it, because if you see just the numbers and you don't know the context, that can be misleading, because someone might be, deciding, super complicated case that, takes ages and has thousands of pages and so forth. But that's the way why it is blocked. But it also creates this problem that you mentioned, that there are certain court presidents who basically stop deciding cases and not working anymore in the judicial function, which is highly problematic. So first you need to have this information publicly available, And then I think it's utterly illegitimate for court presidents to not take part in adjudicative function at all. They are still judges, and they should have their own, case law. So a standard practice, a good practice, is that you, for instance, have a rule that, for instance, applies at the Czech Constitutional Court, that vice presidents have 50% caseload and the president of the court has 25%. And that means that he gets 4 times less individual constitutional complaints. And of course, in abstract review, the Constitutional Court, sits at full session, so the court president must be present as well. So that's something, I guess, that is doable. Of course, if you have a huge court in the capital that has 150 judges, and you have to run that, probably the caseload of such court president may be even lower, let's say 10% or something. But there must be at least something that these court presidents are not losing their ability to be judges, because then it's very difficult for them, and they know it, and they say it in private, that it's extremely difficult to return to the courtroom if you are not judging, if you have not been judging for several years.
Okay, thank you, David. So now is the last parts of the presentations. This is about the presentation about Georgia. I know that we've taken a long time, and I will try to be as quick as possible, but still we've got some topics to cover. So I will share my slides. I will just introduce myself once again. I'm Kakha Tsikarishvili. I am a member of independent lawyers, the group of independent lawyers. I have a professional experience. I have a small professional experience of working in the judiciary, like in disciplinary chamber and also the assistant to the judge. But I have a long experience of working outside judiciary on different type of projects, of judicial reform projects. Let me just open up my presentation, share with you the screen. Okay, here you are. First, I will just give you a short glance to the judicial system in Georgia, just to know what is the context, just to know about the context. We have 2 separate jurisdictions, the Common Court and the Constitutional Court. We have approximately 340 judges, and maybe even more now, because there have been some recent appointments, and we have 23 judges in the Supreme Court. The judges are appointed for life for 3 years probation period. Criminal cases are tried by 1 judge. In the first instance court, 3 judges on appeal and cassation. Civil and administrative cases are tried by 1 judge, usually by 1 judge. Jury trial, we've got jury trial, but for very limited number of cases. Judiciary is centrally administered by the High Council of Justice, which is composed of 15 members, 9 judges and 6 non-judges. 5 of them, they're appointed from Parliament. Judicial Conference is a self-government body composed of all judges of Georgia, and they are usually electing these members of High Council of Justice. And as they did it yesterday, yeah, there was a judicial conference. They elected 2 members, and it was quite criticized, quite strongly criticized, the way that these members were appointed. But it's a long topic. I will not follow this now. Just very briefly about judiciary, in 2004, 2012, it was strictly controlled by the executive by way of court presidents, by way of using court presidents. So there was absence of political independence. There were confidential disciplinary procedures. The judges were punished for for disobedience. The reforms have eradicated the systemic corruption from the judiciary, but they suppressed judicial independence. The acquittal rate was close to zero. If a judge wanted to acquit, this is very interesting. This is something very interesting. The role, when we talk about the role of the court presidents, they had a very bad role before 2012, particularly if a judge, they were controlling. In fact, they were controlling all cases that are particularly on the criminal cases, and also high profile administrative cases as well. Basically, the court presidents were controlling the outcomes of the case. If a judge wanted to apply a non-preventive measure or acquit the defendant, the judge had to go to the court president, ask for the permission. There were stories. The judges were just crying before the court presidents to give them permission to acquit the guy. There were anecdotes about that happening in the old times. So the court presidents, they were absolutely in control of the adjudication in the court. And this is why we had such a low level of acquittal rates. And in addition, the cases, they were just deliberated in front before the court president. So if you were a judge and you wanted to decide the case this way or that way, you had to talk about it to the court president before the adjudication of the case. So they called it a deliberation before the deliberation with the court president. And there is actually a source of this information, and I can just give you a brief example. When Masaryk became a court president in 2013, he actually, or 2012, I'm not sure about the date, but he actually gave interview later on. He was the president of the biggest court in Georgia, the Tbilisi City Court. When he became president, they brought a list of cases with the outcomes, a 500 case, whatever, 150 cases with the possible outcomes. This case is going to be decided this way, that case is going to be decided that way. The penalty will be 3 years, 2 years, 5 years, and there can be a possible acquittal. So actually, the president of the court was served with a list of cases with the possible outcomes. This is what was a practice in the courts. Actually, this is not something that I'm not inventing this. This is something which is accessible in the media. Because the Masaryk, he disclosed this later on when he talked to the media. This is how the courts were actually monitored. The court presidents were monitoring the outcomes of the cases. Later, after 2012, when the Georgian dream came to the power, promising restoration of justice and creation of independent judiciary, the High Council of Justice was dismissed, actually, and they removed the court presidents from the High Council of Justice, and as well as the MPs. And there was a new composition of the High Council of Justice according to the law. The judges had the power, judges were given the power to nominate the candidates by themselves. And so that's why I'm saying that the presidents, they were just taken out of High Council of Justice, because previously there was no restriction. But in 2012, after 2012, the law prohibited the court presidents to occupy the position of a member of High Council of Justice simultaneously with the court president. And also, it's interesting that almost all the judges have been reappointed after 2012, because 2013, because their mandate has expired. They had to be reappointed. Now, let's move to the court presidents. I'm gonna go through these through the questions and answers. The first question is, how are the court presidents appointed? How are the court presidents appointed? And they, according to the legislation, the presidents are appointed by High Council of Justice with a reasoned decision upon consultation of judges of the respective court. As to the Chief Justice, the President of the Supreme Court, which is the same, is appointed by Parliament for a period of 10 years upon proposal of High Council of Justice among justices of the Supreme Court. Now, what is happening in practice? In practice, the court presidents are appointed among judges who are closely affiliated to the clan, and by word the clan, we mean the judges who are in control of the judiciary. There is approximately 10 or 20 judges who are completely controlling all administrative leverages. In judiciary, they are controlling the entire judicial system today, and we call them the clan because they actually act informally as well, because they are appointing their allies on all key administrative positions, and they are having secret interaction with the government, and they are even influencing the outcomes of the specific cases whenever there is an interest. There's a special interest. So basically, the court presidents, they are very important tool to control the judiciary, and court presidents are appointed among judges who are very close allies to this clan, to this clan of judges. Actually, there was a draft law proposed by the government in 2015 who has proposed the election of court president by judges. However, this version of the law was not adopted. This is a practical example of how a court president is appointed in Georgia. You can see a ruling of the High Council of Justice appointing the president of the city court, and you see, and I'm going to talk about I'm going to talk about the content of this ruling. The ruling says that there was only one application. Actually, the judges, they were given the possibility to nominate themselves for the presidency of the Tbilisi City Court. Tbilisi City Court is the biggest court of the country, and the judges, they were given the possibility to nominate themselves. There are approximately 120 judges in Tbilisi City Court, and they were given the possibility to nominate themselves. But you know what happened? Only one judge has nominated himself out of 120 candidates, out of 120 judges. And, you know, it's a standard reasoning. And what is the reasoning? The reasoning is that the judges are familiar with this candidate. They know him very well. He's a qualified, he has good professional and personal skills, communication skills. He has already been a court chairman before. He has good managerial skills. So the judges, they qualify him very well. They characterize him very well. So this is how the High Council of Justice is choosing that candidate to become a president of the city court. That's it. That's the entire ruling, you know, and this is a very standard ruling. When you take a look at the appointment of court presidents in Georgia, that's a very standard ruling. You know, there's no competition among the judges. There's only one candidate, and the High Council of Justice is appointing this one candidate to become a president of the court. We don't have so the next question is, do we have any criteria for the appointment of court presidents? We don't have any criteria for the appointment of court presidents. Next question is, how long are the court presidents appointed? And the court presidents are appointed for a period of 5 years. Chief Justice is appointed for a period of 10 years. The next question is, how are the court presidents removed? And the court presidents can be removed by disciplinary decision on, you know, different grounds as well, because like you know, the death of the candidate or voluntary resignation. Or I'm not going to talk about these grounds, but I'm going to talk about the ground of breach of professional discipline. This is by way of disciplinary decision, they can be removed. However, this was not always the case, because previously this court president of the biggest court, Mamuk Ahmediani, he was removed without using disciplinary procedures, and it happened in 2015. He was removed without any kind of disciplinary procedures, just by very simple procedure, which was not prescribed by the law. He was just removed without any criteria, without any formal procedures. He was removed because he talked openly about problems in judiciary, and he was just kicked out of the court of judiciary very easily. Unfortunately, he has appealed to the court against his removal. But of course, the clan is operating. The clan is controlling the entire judiciary, and of course, the courts have not granted his appeal, and he was not restored to his position. Now, the next point is, what are the functions of court presidents? And then I classify here the legislative functions are following: HR functions, appointment of dismissal, appointment and dismissal of court staff, disciplinary supervision of the court staff. However, there's no connection to the judicial disciplines in 2017. So the court president, they have nothing to do with the court, with judicial discipline after 2017. Court manager is we also have court managers, and what is their function? The court manager also has some HR functions. They are appointing and dismissing employees of the court, except the head of the court bailiff service and the assistant judge and the court clerk. And basically, the court managers, they can do everything that the court president can do. You know, like supervise the staff, supervise the court building and facilities, and disciplining the staff, and customer service and case flow, contemplating the case flow and everything. They can do everything that the court presidents can do, except for assigning the cases to the judges. Now, the next is assigning the complaint process. The court presidents have complaint powers, so they can receive complaints from the citizens, but the complaints against court staff and not the complaints against judges. Then the next function is the case flow management and the delay reduction. And this is the legislative power. The court presidents, they have to study the reasons of the case delay in the court, the clearance rates, the reasons of trial adjournment, and report to the High Council of Justice. So once again, I'm saying it, they have to study the reasons of the case delay and the clearance rates, and they have to report to High Council of Justice. However, they don't do it. Usually they don't do it because we have requested this information from the court presidents, and they didn't give us anything. They just didn't give us anything. We requested this information from different courts, and they didn't give us anything. They said, so we're not giving you this information. Go to the High Council of Justice. Go and ask the High Council of Justice. And I didn't go to High Council of Justice because I knew the response would be the same. Actually, to my this gives me the conclusion that they don't do this function. They don't actually observe the case flow management as it is, and they don't report it to the High Council of Justice as it is described by the law, because they have to do it in writing. Okay. The next question, the next function is ensuring the order security, courtroom security, the court security in the court, inside the court building. And they can also punish the violators inside the building. The questions are, do they have disciplinary power against judges? No, they don't. Do they have any power to promote or appoint judges? No, they don't. Do they have any relationship with media? Some of the court presidents, they can have a relationship with the media, but it's not very frequent. We can see some of the presidents on TV very, very rarely, but usually the court presidents, they don't appear on TV. They don't talk to the media very much. Do they have any separate budget? They don't. The court in Georgia, the courts, they don't have budget. There's no independent budget for a court. Everything, the courts are receiving everything from central office. They're even the papers, desks, computers, salaries, everything they are receiving from the central budget and from the central office. The courts in Georgia, they don't have a separate budget. Public relations, not very much. You know, the presidents in Georgia, they are not very much involved in the public relations. I'm not talking about president of the Supreme Court. It's an exception. The president of the Supreme Court does have public relations department, and also she's interacting with media, but not very much the others, other court presidents. Now, here we have the recommendation. The group of independent lawyers, we made the recommendation about the court presidents in Georgia. We think that the court president, the way of appointment of court presidents should change, and they must be appointed by rotation, so that the rotation takes place every, sorry, no, not by rotation, but no, so not by rotation, by lottery, so it takes place every 2 years, and the judge who has already had this position once he may not participate in the lottery. And we also think that the court president, they should have some kind of quota for adjudication of cases, and they can have some reduction, but not more than 10%. We also think that court presidents should have only representative functions. They should not interfere in the administration of the court. It's not just the court. We think that it's the court manager who must administer the court personnel and the services and computers and relationship with the public and complaints and everything. We believe that courts have managers and they can do the task. However, so yeah, exactly. Basically, we have been thinking about retaining only ambassadorial functions for the court presidents because of the negative experience that we had in the past. And I'm going to finish here by just saying that once again, that in Georgia, we do have negative experience with the court presidents, because the court presidents, they have been interfering in adjudication of cases, manipulating with the case assignment. They have been rigging cases with the judges. Usually it was like it was described in the Western literature, transmission belt, ensuring the political control of the judiciary. That was usually the role of the court presidents from a very long time, since the communist time. When you take a look at the system now, we can see that we have a lot of remnants from the Soviet time. We still have a lot of remnants from the Soviet time. We have some kind of bureaucratic culture. The judges, they think that the court presidents are their superiors. They actually, the court presidents do have power over judges. The court presidents are centrally coordinating some of these informal practices of case manipulations and just rigging the outcomes of the cases. And court presidents, basically, when I always say this, when you have a court administration, usually the court administration should have nothing to do with the outcome of the case, right? I mean, this is something like a clear-cut principle. The court administration should not care about the outcome of a specific case. But in Georgia, it's not like that. The court administration in Georgia always cared of an outcome, always cared for the outcome of a specific case, particularly when it comes to political cases, high monetary value cases, election cases, and so on, high criminal cases with a political motivation, and so on and so on. Basically, we do have this type of a shadow management of the judiciary when the court administration is interfering in the outcome of a case, and this is something which is the biggest problem for Georgian independence, for judicial independence here in Georgia. This is why we are actually coming up with this idea of reorganizing the function of the court president, just getting rid of everything, only retaining ambassadorial function, and just delegating all the other functions to the court manager and also the court chancellery. So this is what I wanted to say at this point. I'll be happy to answer your questions. Okay. Please.
Can I?
Yes, David, please.
I just wanted to ask you, so it seems to be, correct me if I'm wrong, that court presidents earlier on, they got some extra money for the fact that they were holding the position of a court president.
True.
So how much money that was, and who was deciding upon that?
It's a very good question. I don't have the exact answer because I have not looked in the appropriate legislation right now, but this may be approximately 10% of judicial salary, maybe 20% increase from the judicial salary. So if the judge is getting a salary of let's say 15,000 Georgian lari per year, the court president will have approximately 70,000 per Georgian lari per year.
Yeah, but what's the problem with that?
Okay, the problem with that is that the court presidents, some of the court presidents, they don't do adjudicative functions, and they are just doing administrative functions, and they do less job. They are just monitoring the outcomes of cases and, just politically controlling judiciary.
Can I interrupt? I just looked in law. First of all, thank you for presentation. I'm Tsikarishvili from Public Defender's Office. For president of first instance court, for president in first instance court, it's additional $600, which is approximately $200 for the
per month, right?
Per month, yes, per month. Yes, for appeal courts, it's $500, and for Supreme Court presidents, it's $1,000 per month for sure.
Okay, thank you. I think this is a clear answer to your question, David.
Yeah, so it's some money, but if it's determined by the legislation, I mean, I don't see such a big issue. Anyways, so that was my first question. The second question, you said that court presidents were given certain extra additional benefits beyond money. So again, if you
true, yes, court presidents are given.
Yeah, and one more question, if I understood you correctly, you would like to reduce the caseload of court president only by 10%, not to 10%, but by 10%.
By 10%, yes, by 10%.
Well, it very much depends how big courts you are having, but basically no one would do that job here in the Czech Republic because so much work. I mean, of course, depends, how the work is divided between a court president and court manager or something like that. But in the Czech Republic, I mean, you have to take care of the stuff of the buildings, basically of everything, go to the Ministry of Justice, meeting with other court presidents, helping to do the courses for judges, talking to new employees, to new judges being assigned to court. That's so much work that basically 10% reduction would be considered hilarious here in the Czech Republic. So that's just my perspective. And then you mentioned that court presidents are removed by the High Council of Justice. So the High Counselor has a complete discretion, or how
Yes.
this
Okay.
procedure
Good
operates?
question. Okay. Okay. Should I answer or you just finish?
Yeah, I'll finish for now.
Okay. First, your question was about the additional benefits. At this point, I will say it, and my colleagues may correct me if I'm wrong. One benefit that the court presidents have is the car. Office car, which serves to the court president with the driver and the petrol. So they have certain type of certain limit of petrol every month, and they are spending it. This is one benefit that they do have. And they also have a biggest, how do you say, cabinet inside the courtroom, the biggest one and the largest one. And they are also served with the assistants or secretaries, additional secretaries, and so on and so on. Basically, they are in charge of, they are the bosses. They are the bosses inside the courthouse. That's the benefit. That's about the benefit. Your second question was about, I forgot, to just remind me, please.
Yeah, there was about dismissal of High Court of Justice
Dismissal.
and the
Yeah.
reduced caseload.
Yes. Okay. Dismissal. Prior to 2017, there was a very vague provision in the law about the dismissal of the court presidents. Actually, there were no grounds listed by the law. So it was just saying that the law was just saying that the court presidents are dismissed and they are recruited and dismissed by High Counselor of Justice. That's it. That's it. And there was this famous case of Ahmed Diani in 2015. Actually, but I'm sorry, there was one exception. There was a provision in the disciplinary law according to which the court president could be dismissed for failure to exercise managerial duties or for improper exercise of managerial duties. However, he could be prosecuted as a judge and as a president at the time. And this was some kind of problem with the law because the court president had to be prosecuted as a judge and also as a president. That was a kind of problematic. However, in 2015, this biggest court, the chair of the biggest court in the country, Tbilisi City Court with 120 judges, he has started to make statements against government, against the judicial government, against judicial leadership. He started to talk about mismanagement in the judiciary, about problems of judicial independence, so on. And he was just kicked out very easily by High Counselor of Justice without any procedure, without any formal procedure, I would say, pre-described formal procedure, and without any pre-described formal criteria. He was just kicked out of the presidency. He remained a judge, but then he left by himself because he didn't want to be a simple judge, just he wanted to be a court president, okay? And then in 2017, they changed the law and they said they made a list of grounds for the dismissal of the court president, like incapacity, like death, like voluntary resignation, and disciplinary proceedings. And now the court president can be removed forcefully for the breach only by way of disciplinary proceedings for failure to exercise proper administrative duties. That is something which is in the law. And this is done this is done not by High Counselor of Justice right now. High Counselor of Justice is a prosecuting body on disciplinary cases. And we have a separate body which is adjudicating disciplinary cases. It's a board which is composed of lay members and judges. And this is an formally independent board. And this board will take decision on the dismissal of the court president after disciplinary procedures. And you talked about also the reduction of case workload for the court presidents. Okay, well, because we are only retaining ambassadorial function for the court president, this is our proposal. That's why we decided to reduce the workload only by 10%, because the court president will have only ambassadorial function. I understand that this is not a classic solution, because in Western countries, the court president can be a very useful public figure. But in Georgia, they usually had different roles, like transmission belts for political will and things like that. So we decided to get rid of the court president altogether, or reduce the functions to only one single function, which is the ambassadorial function. That's where we are now. We just have this proposal, but it doesn't mean that the Georgian government is going to adopt it tomorrow. The Georgian government is actually against all kinds of radical changes inside judiciary. They're not going to touch the court presidents right now, I'm pretty sure. But if there's a political will, we want to reorganize the court presidency. We want to have a rotation, we want to have a lottery for becoming a court president, and we want to have this ambassadorial function retained.
Okay, thank you very much for your explanation. I'm really sorry. I have to leave. I have another meeting at 2 p.m. So we are
Okay.
almost 2 hours by now.
David, I think we're coming to close anyway. So anyone, please, anyone from our group, do you have questions? David, so we shall leave you, but you shall leave us by now.
Okay, bye-bye.
Okay, David, thank you very much. Thank you. You can leave
Super
us.
interesting. Bye-bye.
Thank you,
Okay,
David.
bye. Eka, şey hocam, what do you say? I think we're coming closer. I can close the recording, or should I continue recording? What do you think? We should just sum it up. So I will close the recording, and I think, okay.